Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Temp check. What kind of summer are we having this year? A family road trip summer? A beach bum summer? Or a wake me up when the sun sets summer? With Instacart, choose your own adventure and skip the shopping side quests. Where available, you can get ice cream delivered to your hotel, sunscreen to the pool, or cold brew to your bed. Well, door, in as fast as 30 minutes. Wherever you find yourself this summer, you can get the goods. Download Instacart for free delivery on your first 3 orders. Offer valid for a limited time. Minimum $10 per order. Excludes restaurants. Additional terms and fees apply.
Okay, it's time to commit. 2024 is the year for prioritizing yourself. Begin your new smile journey with Byte, and you could start seeing results in just 2 to 3 weeks. Just order your at-home impression kit today for only $14.95 at Byte.com. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces. Plus, they offer financing options, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning, this episode contains discussion of the murder of 2 girls.
Well, there was a time not too long ago where we all thought that we would be spending today and the next couple of days in a courtroom in Carroll County, as there was a multi-day hearing scheduled to help resolve some of the issues still outstanding in the Richard Allen case. But we are not in that courtroom in Delphi, Indiana today, and we will talk about why and talk about some other filings in just a few minutes.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders, objections, replies, and a second motion to dismiss.
So there were a bunch of filings in the case, most of them from the defense, one from the prosecution. Before we get into those filings, for some reason, as I was reading these, especially the ones from the defense, it reminded me of an experience I had years ago. Maybe you're too young to have such an experience, Anya. Do you remember record stores?
No.
I remember like going into a record store and seeing what I thought was a new album by a performer I liked. And I would go, I said, oh boy, it's a new album by a performer I liked. And I take it home and I open it up, and it turns out it's not a new album. It's a greatest hits album. A lot of the same songs, maybe like one or two new songs at the most. I was always very frustrated by that. I don't know what made me think of that, but why don't we
Apropos of nothing.
start talking about the filings?
Yes. I guess to start off with, we can talk about the prosecution filing, which is the objection to defendant's motion to continue. Obviously, since we're not at the hearing, this one didn't work out for Nick. And it's the state's objection to continuanes, whoops, typo there, filed by the defense. And this is, I would say, in my view, before we get started, so this is the state saying, I want the hearing to go on. I don't want it to be delayed. And whether or not we agree with that statement, let's set that aside. Let's just note that I don't think this was necessarily one of McClellan's strongest filings recently.
Yeah, and as an example of this, I want to read a little bit of it. He says, the state does not believe the court loses its jurisdiction once a motion to recuse is filed. That only applies when the recusal is mandatory. In this instance, it is not, end quote. So he's saying, well, the defense said you have to do the continuance. I don't think you have to. I don't believe that. But then he doesn't cite any case law to back that up other than his own belief.
Right. And I mean, when we talk about the actual, I guess, argument beneath all this, whether or not Judge Gull should have to recuse herself, I think the Indiana Supreme Court made that pretty clear when they did not have her recuse herself back when all this, a lot of this drama went down between the defense and Judge Gull.
But of course, last week in their filings, the defense said, well, the Indiana Supreme Court didn't have all of the information they needed.
And then they proceeded to cite a lot of information that the Indiana Supreme Court already had, including some other very nitpicky stuff.
Yes.
So not exactly super compelling. I believe that it looks more like a stalling tactic than anything if you keep asking for her to recuse herself. I mean, we'll look at the breakdown later, but I don't believe there's really any merit there. And I think I understand where McClellan is coming from here, but I think it could have benefited from some case law here as well.
Yes.
And this is another quote kind of describing McClellan's feelings on the matter. Quote, that how can the defense be prepared to not at least go forward with the state's motion in limine when it was prepared on May 7th, 2024? End quote. So he's commenting about, like, we've all had this for a while. How are they not ready to go at this point? I think this underscores the amount of stalling that is becoming clear in terms of what this defense team is prepared to do going forward.
McClellan says the state believes the only reason the defense is attempting to continue these hearings is an attempt to delay the proceedings.
I believe that is correct, and I think that's obvious to anyone who's viewing this situation.
And then McClellan makes a factual error. He says the defense did contact the state, and the state did notify the defense that they object to this continuance, but the defense did not state that clearly in their motion, and in quote. And actually, the defense did.
They stated that very clearly in their motion, in my view. So I don't know. I don't know what he's talking about there. That seems to be an error, because the defense noted that he objected. So I don't really know what else they're supposed to do there. And yeah, I think that's kind of it.
So he says the defense wants to continue this because they've asked you to recuse yourself, and they say you can't be making motions and ruling on motions when you've been asked to recuse until that's settled. I don't think that's so. And then that was his filing, and then the defense pretty quickly filed back a reply, defendant's reply to state's objection to defendant's motion to continue. And like the first thing they do in this, I believe, is they say McClellan made a mistake. We did clearly put the fact that he objected in our original filing.
They also critique him for not citing any case law, which I think is fair. And then I'll read a quote from this. Quote, furthermore, on May 15th, 2024, prosecution provided a new phone extraction that the defense believes will be useful for the defense at the motion in limine hearing, but needs additional time to review this voluminous extraction, as well as the anticipated report that will be filed by First Sergeant Christopher Cecil, that will also be useful in the motion in limine hearing. So who is First Sergeant Christopher Cecil? We've heard this name before, but if you don't remember, that's okay, because there's a lot of moving parts in this case. Cecil is a officer with the Indiana State Police, and he worked on the Kegan Kline case. He was responsible for digging out all the data, all the information from Kegan Kline's devices, and specifically digging into the child sexual abuse materials on there. So he's an expert when it comes to extracting phones, getting information off of phones. And
so some of the more details about this phone extraction that they refer to would be discussed in later filings. So kind of stick a pin in that for now.
Yeah. Next, let's get to the order issued from Judge Frances Gull. And the upshot of this is that she canceled all the hearings this week as the defense requested.
I'm going to read from it. She writes, quote, "As the court is now required to review and rule upon the 42-page pleading, the court is compelled to cancel the pretrial hearing previously set with counsel's agreement."
So this is interesting, Kevin. A few people have asked us this, and so I wanted to answer them. And even, people who covered the case have asked us, I think the sense is, well, the judge ordered it, so this is the judge delaying things, right? Who's responsible for this delay?
Well, this is basically done in response to a request from the defense. And you can say, well, this is a legitimate request by the defense in order to protect Richard Allen's rights, or you can say it's a stalling tactic, but it's done at the request of the defense. And I would just like to, again, reread what I just said. The court is now required to review and rule upon the 42-page pleading. The court is compelled to cancel the pretrial hearing previously set with counsel's agreement. I think there's a lot of passive-aggressive stuff in there. I think she's clearly unhappy with the length of the pleading, and she's making it clear we set this hearing with everybody's agreement, and now you're making us delay it.
I want to say something before we get into our next.
So she's not too happy.
No, she's obviously not too happy. I don't think anyone's too happy about this. Again, we have the prosecution ready to go. We have the judge ready to go. The defense lags behind. Now, that might be confusing because it's seen as an antithesis to their tough guy rhetoric, right? The tough guy rhetoric is, we're ready to go. We're going to do this. We're going to get him out of prison. That's never been the actions that have followed up. I mean, I think withdrawing speedy trial, whiffing on this, latest 3-day hearing when it's basically like, let's talk about your theory of the case, which you've attempted to outline so far. It really, I believe that what we're seeing right now is the formation of a playbook that will continue for a long time. I believe that we're in for a lot of delays, a lot of future delays, and that we're going to see tactics like this where, if you file something requesting the judge recuse herself, then you know that if you file that a couple of days out of before a hearing, then you'll be able to not have to go to the hearing. I think this is just what we're going to see going forward. I think everyone should be braced for that. I personally hope I'm wrong because I think the more this drags out, the more painful it is for everyone involved. But that is what I believe will happen. And it will be coming from the defense. And they will be saying repeatedly, it's the judge's fault, or it's the prosecution's fault, or it's police's fault. It's everybody but our fault. But that won't necessarily be the case unless circumstances change for some reason. But I really think that when you're dealing with this defense team, you have to look at the rhetoric, but you also have to look at the actions. And the actions speak to tactics of delay and, I guess, trying to thwart any proceedings that they don't feel prepared for. So just something to watch out for.
What's the next filing?
Next filing is defendant's second motion to dismiss based on newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. So now we have something that's not really to do with the delays necessarily, but is very, certainly a kind of a meaty thing, a motion to dismiss.
And you see, baffled is why I was talking about the unexpected greatest hits collection. And it's because of this motion, because as we will discuss probably in too much detail in a few moments, most of the contents of this filing are like a greatest hits album because most of this is stuff we've heard before.
One thing about this defense team that I think about sometimes is just, it's always important for us as, whether you're a layperson or a lawyer like Kevin, all of us who are not a party in this case, it's important to scrutinize the goal of a filing. For instance, in the McClellan filing we just talked about, his goal is to say, Judge, let's have the hearings anyways. Stop letting the defense stall. Okay, that's his goal. Whether or not he cites law or examples or reasons his way into it being successful is another matter entirely. So, here's a very silly example. Let's say I want to make a filing in a court case about how I deserve a free lifetime supply of cereal. Maybe I make some pretty good point. That's a pretty maybe outlandish, maybe over the top request, but maybe I make some really good points, like the cereal is good for me. I do a great job marketing it, so it's mutually beneficial for me and the cereal companies. If I get it for free, I won't be stealing it and causing a ruckus at area grocery stores. So maybe I'm making some good points, but it needs to rise to the level where I guess the law agrees with me that I should get this. Again, there's no law around that. It's a dumb example. Ignore me, but
your lobbying efforts have failed. You've not gotten that law passed.
It's been a disaster, frankly. I've spent all our money on it. And so the sum of an argument in a filing does not always add up to the ultimate goal of said filing. And something like a motion to dismiss, it takes a lot for a case to get dismissed. There was an initial attempt to get this case dismissed. It failed. And what I'm looking at when I'm reading this is not just are any of the points good, but does this filing rise anywhere close to, I guess, the watermark where we need to get this dismissed?
Good question.
Yeah.
I think we can probably speculate and make pretty educated guesses
No.
about how the judge is going to rule on that.
No.
So,
but that doesn't mean it doesn't have anything worthwhile in it, or that it doesn't have anything that can be positive for the defense at trial. I'm just trying to say we can analyze it and say, nice try on the dismissal thing, but maybe this will help you out in cross, or maybe this will help you out when you're dealing with this kind of witness. It's not necessarily a zero-sum game, although when you do broadcast all of your strategies for trial in your initial filings, then maybe that does take some of the sting out of them as far as the prosecution is concerned.
Have you ever covered a carpet stain with a rug, ignored a leaky faucet, pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
When you need to work quickly and confidently across different apps and platforms, consistent quality communication is key. Whether you're writing documents, emails, or presentations, you need Grammarly. It's an AI writing partner that helps you get your work done faster with better writing. It's always there to help because it works where you work, across 500,000 apps and websites, so you can get more done no matter where you're writing. Grammarly is the gold standard of responsible AI, trusted by millions of professionals for 15 years. It gives you personalized writing suggestions based on your audience, goals, and context, plus tone suggestions to help you navigate even the most difficult work conversations. 96% of users agree. Grammarly helps them craft more impactful writing. Sign up and download Grammarly for free at Grammarly.com/podcast. That's GRAMMARLY.com/podcast. Grammarly. Easier said, done.
So they start out by talking about, hey, do you remember there was a hearing back in March where Steve Mullen, who's a member of the prosecutor's team, talked about how some interviews with Brad Holder were recorded and then erased. Hey, maybe there's some smoke there. Maybe that was nefarious. Huh? And what was interesting about that to me was that same day, there was another hearing where the subject under discussion was the leak of graphic crime scene photos by Andrew Baldwin's friend and colleague, Mitch Westerman.
And top strategist.
And certainly there was some smoke there because, this guy's Andrew Baldwin's friend and he's leaking these things.
Also, apparently there are texts between them where they're talking about leaking to the media. Weird.
But ultimately, there was no hard evidence that Andrew Baldwin was directly involved in the leaking of the crime scene pictures. And ultimately, there is no evidence that this erasure of interview recordings was done deliberately. And so it seems to me that Judge Gull is applying a pretty consistent standard here, which he is not going to say that Baldwin's team definitely did something wrong or the prosecution definitely did something wrong unless there was hard evidence to prove that. And there doesn't seem to be hard evidence that the erasure of interviews was done deliberately or that the leaking of crime scene photos was a deliberate choice by Andrew Baldwin.
Yes, and I find it weird and interesting that the defense seems to want to apply one standard to themselves and then a completely different standard to the prosecution. And perhaps that's just what happens in these cases. That's possible, kind of the adversarial relationship. But I would argue that that may be the case, but that doesn't mean I'm going to find it compelling.
So the next thing they talk about is they say, well, it's highly suspicious that the prosecution has never turned over to us data from the phone extraction of Bradley Holder. Bradley Holder is one of their suspects, one of the defense team suspects.
Yeah, emphasize that point.
And it's interesting. So the prosecution has done something wrong by not sharing this phone extraction data. However, it is not the least bit clear that this phone extraction data even exists. And I want to read point 10, quote, during a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17th, 2017, end quote. So they don't even know for certain if Holder turned his phone over.
Or what that means. Does that mean that police by hand sort of skimmed through his phone and checked things? Does that mean they extracted things?
Yeah.
Or did they give it right back to him without taking any data? Like, what does that mean?
So they are building this whole foundation, this whole castle, the sand castle. Everything is built on the idea that they didn't turn phone extraction data over when we don't even know if they did the phone extraction study, and we don't even know for sure if they ever had possession of his phone.
I'm going to talk about this later, but like some of the logical leaps and the assumptions, it almost reminds me of, sometimes in American politics, I'm sure politics everywhere, one side will adopt some kind of attack on the other side and will take a very bad faith reading of every single thing. It's sort of like kitchen sinking. When you're kitchen sinking in an argument, you're throwing everything but the kitchen sink is in, and you're not just focusing on like egregious examples or well-documented examples or evidence-based examples. I'm just saying, Kevin, legitimate criticism. Also, I don't like the way you look at me. It's like, what? Like, I mean, it's disheartening to see because over time it becomes difficult to unpack what's legitimate and what's totally illegitimate or made up. And it becomes hard to analyze because of that.
It's also like if I get very upset with Anya for not bringing me home a piece of pizza last night, I don't know for a fact that Anya went to a pizza place last night, but I do know that she drove near a pizza place that she likes and she knows I like, and I sure didn't get any pizza. So what do you think, folks?
I'm surreptitiously pushing a big stack of pizza boxes out of Kevin's view right now.
So it just seems that they're making accusations and asking the judge to take the incredibly serious step of dismissing the case based on the prosecution not turning over something they may never have had.
And here's an important matter. They could bring this up to the jury. I mean, if they're allowed to do the Odinism thing, we'll get to that. But they could bring it up to the jury in the sense that, like, look, they did a sloppy job. They didn't collect this properly. That's bad. Look, if they did a sloppy job on this, maybe they did a sloppy job on everything. That's a decent argument. You can do that. And I think some jurors might find that compelling. But when you're going at it from this means there's a conspiracy, then, what's the difference between that and some like YouTube comment section lurker? I just don't even understand at this point.
I think if they asked Lieutenant of the ISP Jerry Holman under oath about if a phone extraction was done, and quote, Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI, end quote. So we have a member of the command team saying that as far as he knows, there was no phone extraction and they just looked through the phone. So maybe Holder just gives them the phone for a few minutes and they just look through it.
And which makes sense in the context of him not being a particularly interesting suspect to them and perhaps being someone that they need to cross off a list and then move on from because there's no evidence implicating him in the crimes.
And in fact, he has a pretty good alibi.
In fact, he has an alibi and there's nothing linking him to the crime scene. So when we think about the early days in the investigation, hundreds of people are being called in. Having a few tips about how a guy has a creepy Facebook and the fact that he has some tenuous link to one of the victims does not put someone at the top of the pile. And this is where we're going to talk about the rhetoric of person of interest versus suspect. To a certain extent, there's like euphemistic differences, but I also think suspect is often thrown around as a very loose term. But a lot of hay is made of that, nonetheless.
Yeah, it's very unclear because different people define suspect differently.
Yeah, and it's a matter of, a person of interest might be someone there's no evidence for necessarily, but we want to know more. We want to know what this person knows, what they saw. Let's look into it. I think a suspect doesn't have to be charged or, arraigned or anything like that. But a suspect, there's like growing evidence against them, whether or not they're charged. And I think the evidentiary difference, but I think people use suspect and person of interest interchangeably. I know I have in the past, which may be improper, and so I apologize, but it's a matter of, suspect could mean everything from like, we want to know more information about this guy to like, we think this guy is the main guy who did it and we're going to go for him. People use language in a way that's looser than you want sometimes.
And certainly people in casual conversation among themselves or even in emails with colleagues may use it in a looser way than if they were making formal public statements.
Why don't you explain that statement, why you said that?
They make a lot of hay out of the fact that Doug Carter referred to Brad Holder as a suspect in emails to FBI agent Jay Abbott.
Mm-hmm. Who is then the head of the Indianapolis FBI. And yeah, I guess I'm just like, okay, I would say, like, who is a suspect in the case in 2017? I would say Ron Logan. Ron Logan was the man who owned the property where the bodies were found. He had allegations in his past about abusing female partners. He was heavily investigated by authorities. They served search warrants on his house. He got thrown in jail over probation violations. They came at that man hard, and perhaps for good reason. If he had a violent history and he was there and he lied about where he was, he had some story about his cousin driving him to a fish store and then that didn't pan out. So, I mean, I could understand why I would call that a suspect, but we're not aware of any probable cause that was gotten on Brad Holder. I think you have to talk to everyone who gets tipped in, at least in those early days. You don't want to miss anything, but that doesn't mean everyone's rising to the same level.
They also find it odd that there no phone extraction of Brad Holder's phone, but his son Logan's phone is the subject of a phone extraction. His son Logan is in some sort of a personal relationship with Abby Williams. It is an unfortunate fact, but a true fact, that often when a woman or a girl in this country undergoes violence or murder, the person responsible for it is someone close to her, like a boyfriend or a husband. And so it's kind of a basic investigative 101. In those circumstances, you look at the boyfriend, you look at the husband pretty carefully.
It makes the most sense in the world that they would want her alleged boyfriend's information more so than his father, who had an alibi. Like, let's not forget the alibi, folks. I mean, that is pretty bad. That is pretty bad for this defense argument.
I'm going to read the concluding paragraphs from this particular section. The defense believes that the above information provides strong circumstantial evidence the law enforcement did extract the data from Brad Holder's phone on February 17, 2017, and has not turned it over to the defense. Logic and common sense support this belief. If law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be the law enforcement was completely and utterly inept. So in other words, we don't know if they have it, but they should be punished for not giving it to us. And if they don't have it, well, they're just dumb.
I really feel like these paragraphs sort of creep into maybe something that you could just find to be like a vehement argument into conspiratorial thinking. You're saying without evidence that they must be hiding this crucial evidence. What's your evidence for that you didn't get it? Then there's an alternate perspective that it just was never collected because it was never considered as important because this is a bad theory and law enforcement dismissed it quickly, which they very much have the right to do. So it's like most of their argument around this just is you don't agree with our theory and you think it sucks. And that's, you shouldn't. You should think it's great like we do. And it's like, they're not obligated to do that. They're obligated to go where the facts lead them.
And if you're going to take the huge step of dismissing a case, you need there to be solid evidence of wrongdoing. And that has to rise above a level of saying, well, we think they might have this information. And if they do have it, they didn't give it to us.
Yeah,
that's just speculation.
This is very, very weak and disturbing to see it lapse into such conspiratorial thinking, because I just feel like that has never served this defense team particularly well.
Along similar lines where they're upset about things that seem to have little evidence behind them, Brad Holder says that he was interrogated at some point for an extended period at the Logansport police station. He said it took about an hour and a half, and the police have not turned over to the defense any records about this interrogation. And essentially, as far as I can tell, the only evidence we have that this interrogation ever happened was the word of Brad Holder, who the defense generally says is not someone to be trusted.
Or who doesn't seem to exactly have a firm recollection on what happened to his phone during that initial interview. I mean, like, if he's not even completely sure about that, then I wonder, is it possible he's making an error here? He's conflating two events. Is it possible that it happened, but it was with, we've heard about kind of almost splinter groups from the investigation, like the one involving Todd Click, Greg Ferenczi, and Kevin Murphy. They were looking into the Odinism thing. So were there other groups going around doing that? I mean, I would hope not. That feels like it would be getting pretty disorganized, which I think is worthy of criticism. But I also, I don't know. This all seems like reaching.
And again, Jerry Holman, who is one of the people running the investigation for the Indiana State Police, according to this document, he doesn't really seem to know about this alleged interview between Mr. Holder and whoever. I'm quoting from the document, quote, "At a recent deposition, when Unified Command's Jerry Holman was asked about how the defense could obtain any information about this second interview, Holman said he had no idea, but encouraged the defense to reach out to the Logansport PD to find out," end quote. So it appears that Holman doesn't have information about this alleged interview. And again, the only reason we have to think that it happened at all is Brad Holder.
Yeah, I guess I would want more than his statement at this point to conclusively lock down that, because I don't.
I would think if it happened, your suggestion that maybe it was Click and Ferenczi and Murphy would make sense. I would also assume there would be some sort of record at Logansport over who is being talked to in their interrogation rooms. Police are professionals. They know that most things they do may potentially be discussed in a courtroom in a trial setting, so they keep very good records. So I would assume the Logansport PD would have a record of who was in certain interrogation rooms at their police station at certain times.
I'm just not convinced this even happened. Anyways, so there's a lot of hay made about alleged discrepancies about Holder meeting Abby Williams.
He apparently at different times has had slightly different recollections of the number of times he met Abby Williams.
And, quote, also at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met victim Abigail Williams, 2 times, and that one of Brad Holder's meetings with Abby Williams took place at Patrick Westfall's house.
So from an Odinist did it standpoint, that's potentially chilling, but keep in mind that Abby and Libby were friends with the sons of Holder and Westfall. So it's not really surprising that they might be at their homes.
The side that's saying they're friends with those kids is the defense side, so they kind of explain their own, I mean, I don't know. Somebody going to somebody's house is not exactly bombshell to me. I think some of these things they kind of, we can get into it later if you want, but I think I should say here, a lot of these feel like the defense intends to have these punctuated by like scary organ music behind it. And I think that there may be a reason for that strategically. We're coming up on a argument about whether Odinism is even going to be allowed into this trial at all. So I think you suggested this when we were talking earlier when we were planning this episode.
Yeah, if the judge ultimately makes rulings limiting the discussion of Odinism in this proceeding, it might be more challenging for them to include details about the Odinism theory in their filings. So yeah. There's an argument like, let's go for broke now.
Let's jettison all this so we can stir up our online base that we seem to be catering most of these arguments to, and go for broke at the last minute because we might this theory may be so flimsy that it's actually not, it's literally laughed out of court. And again, this is a team that has been very intent on optics and managing a narrative, managing the press, managing the online cranks. And we know that the court of public opinion is very, very important to them. So how do you get some of this stuff out there? You do some filings before the curtain falls.
And again, they make an awful lot of hay out of the fact that Brad Holder at different times has said, oh, I met Abby once. No, I met her twice. Maybe I met her 3 times. And so they asked Lieutenant Holman in the deposition about this. And I'm going to read from the document, quote, Holman showed no curiosity, no interest whatsoever about why Holder's stories have changed. This attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects, end quote.
So Holman in this situation, basically not thinking it's a big deal that a guy doesn't remember how many times he met his teenage son's girlfriend or alleged girlfriend years ago, is a sign that Holman is lying and acting in bad faith, I guess, to cover up for Brad Holder and presumably the other Odinists. That seems like a stretch.
I posit that maybe you agree with Holman that it's not a big deal if a guy misremembers how many times he met his son's friend. Holman says that's not a big deal. Maybe you agree with Holman, maybe you disagree with Holman. But I think that's not an unreasonable position to have.
I think you can make an argument whether or not you agree with Holman. I think that either way, I can understand thinking, no, it would be a big deal. It's a big case. Why wouldn't you remember that? In my own experience, we've talked to people on other high profile cases, and you would be shocked by how selective memory can be, frankly. And that's not always because someone's sketchy, but it's because they have other stuff going on in their lives and it's not necessarily top of mind for them or what have you. There's any number of reasons that can happen. So you can be skeptical, or you could believe it's suspicious, or you could believe it's not a big deal. But I guess my issue here is that when you're taking that, I think if I'm arguing that both sides could be reasonable, I could see both sides, then acting like having one opinion must be a sign of bad faith, I think itself is a sign of bad faith. Because I think it's like this, like trying to crucify people for not agreeing with your Odinist theory, which...
And if they don't agree with your theory, then that somehow proves that they themselves are part of the conspiracy.
They're part of the Odinist conspiracy.
And the problem with that is that when you look at the number of people who don't agree with the theory, are they all covering for their friends in the conspiracy? It's like you can never disprove a conspiracy because the fact that there's no evidence of the conspiracy is itself proof that it's a good conspiracy.
Yeah.
But meanwhile, in order for it to work, the conspiracy has to grow larger and larger and larger. And it's not at all clear to me as to why Holman or Carter or Lazenby or Liggett, why they would be so interested in potentially jettisoning their whole careers to protect Brad Holder. Are they that into Odinism?
Yeah, is everyone into Odinism? Are we into Odinism? I mean, like, is anyone who's expressed any skepticism about Richard Allen's innocence into Odinism at this point? I mean, there's only so many times you can trot that out before it starts to sound ridiculous. And this is what I have an issue with. If you want to go and say, hey, the law enforcement made these mistakes, they're bumbling fools. You know, if they made these mistakes, what other mistakes did they made? You know, I mean, that's a good argument. I mean, like, you could do that. That's fine, you know, but when you're attributing malice, you know, when you're attributing everything to some malice or some kind of barely implied conspiracy theory, it just makes your argument just look stupid. It's just not, this is not how you should do this. And frankly, it's not even how you should unroll a lot of this information, because I think you'd be better holding some of these things that you could trot out as really big mistakes that you could hang around law enforcement's neck at trial and make them look bad, and they won't be prepared for it in the same way as when you're just endlessly repeating things in filings. I mean, it's not even about like what's fair or what's good. It's about what's good for your client. And I really don't see how, you know, there's a concept of like hold your fire, you know, like don't just start shooting randomly and give away your position.
The next thing they discuss is Patrick Westphal, who, after he was contacted by the police in August of 2023, apparently deleted all the data on his phone.
And I have two minds about this. One, these guys have made so many errors talking about technology that I'm actually not even willing to necessarily just take that at face value. I mean, they didn't know what geofencing was. They didn't know what phone pings are. I don't know. Then that if they're correct, if he did delete that, I think that's sketchy and I don't like that.
It's odd and suspicious.
That's not a good look. I mean, and also it's not very smart to turn in your phone having just deleted everything. So, I mean, either just don't turn it in. Like, you can't have it both ways. You know, just say I my privacy is being violated, I'm not going to do it, or do it and have it all in there.
So are you saying this, in your mind, proves that Westphal had information on his phone about the murders?
No, there's a lot of reasons why you would delete stuff off your phone before turning it to police. You can have, you know, drug stuff, nudes, porn, otherwise embarrassing things, proof of some personal indiscretions. I mean, it's definitely, it's a terrible look. That doesn't prove Odinism. That doesn't prove the Odinist theory. It's just something that is not good, and I can understand why they're making a big deal about it.
There was another point I had a little bit trouble following. So David Vito of the ISP re-interviewed Brad Holder on August 30th, 2023. And at that interview, he did not extract Holder's phone data. And that's supposed to be a suggestion that Vito, I guess, is also part of the conspiracy. And so my question here is, didn't the defense just argue a page or two ago that this phone information was actually extracted years ago and then covered up? So if they already had the phone extraction, according to the defense, why would they need it again? And alternatively, if the investigators are pretty convinced that Holder has a really solid alibi, why would they need to extract the phone?
Don't you find it suspicious that police didn't take the cell phones of every male in Indiana back in 2017 and extract all of their data? Isn't that kind of weird? Do you think they just didn't want to find where the Odinists were? That's what I think.
Anya's being sarcastic.
People are going to be like, Anya's lost it.
Sometimes it's important to point it out when we're being sarcastic.
That's
because there's
fair.
certainly been things I've said on the show.
I think you have a more dry sense of humor than I do. I think I'm more ridiculous, hopefully. But I mean, either way, I just think there's a concept that, you know, people have privacy rights, and if you're very much on the radar, then there's ways of getting information, whether it's voluntary or you have a warrant or whatnot. But in the early days of an investigation, if someone comes up because they have some sketchy Facebook posts and because their son may or may not be dating Abby Williams, and then that's not necessarily like a green light to go kick down their door, seize their phone, drag everything about them out into the sunlight. It's if they're cooperating, I don't know. It's like they wanted a more draconian reaction to some of this stuff just because now they think that these guys are guilty.
Right. The next point is the so-called mimicked crime scene photos. Do you want to discuss that?
So I don't really want to get into anything.
What is it? What are the mimic crime scene photos?
These were crime scene photos that apparently were on Brad Holder's Facebook.
They were mimicked.
Mimicked. Okay, let's not even call them that because I'll talk about how I feel about what they're talking about is an image that the defense claims is a mimicked image that resembles the crime scene photos or the crime scene images of the girls. And what they're talking about is, I mean, should I explain what is that what you wanted me to say?
Yeah.
So I don't really want to get that much into this because this gets into the leak of crime scene pictures, which never should have happened.
Right.
From the defense. And
we don't have to get into all the details, but basically they posit that these so-called mimic crime scene pictures have girls lying down with sticks on them and supposedly in positions similar to the bodies of Abby and Libby.
I'm going to just say it's my opinion that it's not just that mimicked is doing heavy lifting in this sentence. It's that it actually mimicked. The word mimicked is crushed under the sheer weight of the burden it is attempting to carry. So that's how I feel about that.
Can you elaborate on that?
I think it's a stretch to say that. I think what they're claiming is a stretch. I mean, if you want an example of what I'm talking about, when we previously did an episode with somebody who did an amazing job, who just basically went through Holder and Fields and Elvis Fields' social media. They're two people who are allegedly in this Odinist ring. And he basically compiled all of the images referenced by the defense in the first Frank's memorandum and went through it. And so many things that they claimed looked identical did not. Some of them had superficial similarities and some of them really looked different. And I'm talking about there was one instance where Fields and Holder both had pictures where they were holding arrowheads. They look totally different. It's like that's a pretty common like style of picture if you're into finding arrowheads, which some people are. I mean, I have a picture that's like that on my Facebook.
Yeah.
Like I swear to God, I'm not an Odinist here. Like they have stretched. This defense team is willing to stretch the facts to the point where it just almost becomes ridiculous. And I guess stretch the facts is probably a nice way of putting it, as far as I'm concerned. This is just my opinion.
And then it just is a bit of color. This really isn't super relevant. The defense found out about this photo, however you want to describe it, from an internet sleuth in Georgia, at which point the defense drove down to Georgia to get the picture from this internet sleuth. And why didn't they just have the guy email it to them?
Maybe they think the Odinists are running the email too. They'll intercept it.
It seems odd. If I need like a receipt from a business in like Chicago for something I bought, I'm not going to like drive up to Chicago to get the receipt. I'm going to have it either mailed or emailed to me.
Well, I guess when you don't drive to Georgia, then you can't expense a Georgia hotel.
It just seems odd.
I think it's bizarre. I think it's embarrassing that they continue to cite internet sleuths in their filings. I don't think that's necessary. I just think that's been something that's baffled me for a long time. They've cited YouTubers. They cite this guy. This is not what you really want from a defense team. They have their own investigators. Maybe just, even if you're getting it from internet sleuths, maybe just talk about what your investigator uncovered. I just think it looks inept.
Then they have a list of, there's a bunch of evidence that we think might exist. We don't have proof it exists, but we think there's evidence exists, like this alleged phone extraction, and we haven't gotten it. And isn't it odd that all this information that we think exists, that we haven't gotten it, it all relates to Bradley Holder?
Have they? I mean, obviously,
but Brad Holder is their suspect. So
I don't think they're going through and cataloging everything involving Kagan Klein here.
If they did, I'm sure they could make a case that, we think this particular bit of evidence must exist about Kagan Klein. So I didn't find that too compelling.
And I'm going to just say this. This is one issue I've had with this defense team. I think they've actually made some okay points in here, believe it or not. I mean, it's the different aspects of this. You could say the defense, the law enforcement was sloppy. They didn't preserve this right. They didn't handle this right. They should have been more aggressive. You could make that argument. I don't think that's necessarily a bad argument. I think you could do that and you can make some hay of it. You're not going to get the case dismissed over it, but you could actually go somewhere with that. But the problem that I have is they take the kernels of a good idea that could be helpful for cross, that could be helpful with explaining the situation to the jury, could be actually helpful to Richard Allen, and then they mix it into this big batter of logical leaps, logical fallacies, extreme assumptions, bad faith assumptions, and they just lose it. They just lose whatever point they were trying to make because they're putting too much weight on it, on what they have. And I think that's a problem. I don't think that's good for Richard Allen. I don't think that's good defense work. I think when you're losing kind of the point of what you're even getting at because you're just like falling into this conspiracy theory, I think you're just doing a bad job and you're failing your client. That's my opinion. I'm not going to pretend like I feel otherwise.
All right. So what's next?
Next, we get into, well, we talked about the Doug Carter thing. We talked about suspect versus person of interest. Oh, this is this made me feel like I was like hurtling back in time. So
the greatest hits album.
The greatest friggin' hits album. I grew up on my parents' like best of the 80s, best of the 70s CDs. That's why my musical taste is the way it is, I think. And I remember I loved our best of ABBA and our best of Fleetwood Mac CDs. So I have a more positive view of those. But I think when you're expecting new stuff and you're just getting the same old thing, it's very frustrating. So they bring up Tobe Lesenby, the former sheriff of Carroll County. So what do they have to say about him?
Oh, before that, yeah, they talk about...
before that, I'm sorry.
I'm
skipping some tracks, if you will.
Yes, they talked about the Click letter. They talk about Jeff Turco. So these are the things that were the greatest hits.
So the Click letter was Todd Click wrote a letter to the prosecutor saying, hey, I think it's actually the Odinists. And they're claiming they didn't give that to us quickly. And as we've talked about on the show in the past, if McClellan turned over the Click letter is just essentially citing other things that were in investigative files. It's just a guy's opinion. So having that other information and the ability to contact Click themselves, it's not a discovery violation, seemingly, what they've described. It's just, they continue to make a big deal of this, and then they make a big deal. This is inexplicable.
It'd be like if Anya went shopping and she shows us a receipt showing everything she bought, and everybody gets a copy of that receipt. And then I say, well, I think Anya's made some foolish purchases here. And so I send a letter to someone saying, I think Anya made foolish purchases. That's just my opinion. What's more important is that people have the receipt showing exactly what Anya did. And then they can all independently decide that she spent money foolishly.
How dare you? Airing out all her dirty laundry as usual. This is one that baffles me. I mean, because
I think that's a stupid argument with the click thing, but I can kind of understand it. They bring up Purdue professor Jeff Turco again. Can you explain why I'm surprised by that?
They suggested earlier that this was a witness who supported them, and that Jerry Holman, who summarized an interview he did with Jeffrey Turco, prepared the summary in a misleading way, and then they offered, here's how we would summarize it. And then subsequently, Turco said, well, no, I think Holman's summary was better.
I think the Indiana State Police are telling the truth, not the defense. And if I got embarrassed that badly in a filing, you couldn't waterboard the name Jeff Turco out of me afterwards. I just would not, that would be not in my vocabulary. Who is Jeff Turco? I don't know. I don't understand why they continue to bring this guy up when he basically called them liars. That is embarrassing. I know it caused a lot of people to lose faith in this defense team when they heard from the person at the center of this that he felt that they were misleading. He felt that they were misinterpreting his words. And then it came out that the whole thing was just a logical exercise for Turco anywhere, where he's saying, well, if we start from the assumption that these are Nordic runes, then here's what I think. He's not even saying, yeah, I think the whole thing is such crazy that they're continuing to drag this man into it. And I'm shocked by it because they don't need to. They could just kind of move on that subject. But it's the greatest hits album, so they got to include everything. This is a team that will it doesn't matter how badly something damages their credibility. They will continue to bring it up because, it's a point on the list. And I guess they feel if they have a long list, then that means they have a good argument. But I would say that that's not always the case.
So before I stop you, you were about to talk about this whole Blesenby thing.
Yes.
And here's what this is. So Tony Liggett, who's the current sheriff of Carroll County, and Jerry Holman, who we seem to be talking about a lot today. Liggett and Holman both have said they believe that Richard Allen acted alone in the murder of the girls. Tobe Lesenby, who is the former sheriff of Carroll County, has indicated that he believes Allen did not act alone. And so this is supposed to suggest something. I think one thing it suggests to me is I think they'd been earlier trying to create the impression that law enforcement is a monolith who acts much like the Borg, I guess, on Star Trek, where their only interest is acting as one to protect Odinism wherever it lurks. But this seems to make very clear that people in law enforcement can have different conclusions. Now, keep in mind, these three men all believe Richard Allen is guilty, is charged. They have differing ideas as to whether or not he had any help. And that's not uncommon. One of the best true crime books of recent years was one called The Last Stone by Mark Bowden. He tells the story of the investigation of a crime by some very skilled investigators.
Yeah, the disappearance and murder of the Lyon sisters.
And in the end, he reveals that those investigators, even though they believe the person ultimately convicted of that crime is guilty, these people had differing views as to whether or not other people were involved and the extent of that. People have their own ideas. People have independent thought. And so the fact that these men disagree on some elements doesn't necessarily render any of their opinions void. It just shows diversity of thought. And again, they all agree that Richard Allen is guilty as charged.
Which, again, the diversity of thought thing, because if you had a situation where everyone was answering the exact same thing and stonewalling and saying, no, it must be all this way, then maybe they just agree, but maybe you could make a case for they're all just taking the company line. But when people have to, doesn't that point away from a conspiracy? Because they're not.
If there was a conspiracy, I would think, yes, they would all have the same company line. But the problem with conspiracy thinking is that you can never disprove a conspiracy, because I could say, well, Anya, maybe they're just being smart conspirators, and maybe they know that doing this makes
they're gonna have Tobe Lesenby throw him off with his old it's a group of people doing it, and then they can't say, but yeah, it's all according to plan with the conspiracy. Those Odinists are pretty clever, Kevin. And in addition to that, one thing you might be wondering is, well, is it a big deal if they have different opinions about this? It's a big deal if Tobe Lesenby thinks, I don't think Allen did it. That's a big deal. It's not a big deal if they all agree he's guilty as charged, because all they have to prove is that he killed those kids. They don't need to. And he's doing a lot of work helping them with that by confessing to everybody. So I think it's a matter of, it doesn't really matter some of the trappings. It matters to all of us because we want to know what happened, and we want to know, are other people responsible that need to be punished? So it's not like it's unimportant in the scheme of things, but legally speaking, as long as prosecution side is convinced that, we have evidence that proves beyond a reasonable doubt that Richard Allen kidnapped and killed those kids, it's kind of a moot point. It's kind of irrelevant.
And then they talk about Dan Doolin. Some of these points, I apologize, our analysis is going to be pretty similar. Dan Doolin is an officer of the Department of Natural Resources who early on in the investigation had an important interview with Richard Allen. Doolin has recently said he did not record that interview,
which is a problem for the prosecution, in my view, to a certain extent.
It'd be nice if he recorded it, certainly. But Dan Doolin says he did not record it. The defense says, well, we bet he did record it. And the fact that it hasn't been turned over to us is the sign that they're shenanigans and they're up to no good. And so, as we've said in other instances, you can't dismiss a case based on that. If you had evidence that a recording of that interview existed and had in fact been suppressed or destroyed, maybe now we're talking. But you can't just conjure up something and say, oh, he says there never was a recording, but we think there was. And because of that, you should throw out the case.
We get the vibe that there was a recording, though. Let's put that in a filing and submit that in public. I mean, it's one thing if Dan Doolin is on camera somewhere holding a big box that said Richard Allen's recording and then sneaking around and burning it in a parking lot somewhere. Then maybe you have something. Or if you have him bragging to friends at the bar about how he destroyed Allen's. I mean, there's evidence that could exist for him destroying it.
Or there's also evidence that could exist. Is there anybody in law enforcement who recalls listening to this recording?
Right. Or what happened to it, or where it was filed, or whatnot, or what deposed Doolin himself. I mean, obviously, if he's saying that he doesn't think he recorded it. But here's what bothers me about this. I feel like it looks sloppy that Doolin didn't record it. I feel like that, I mean, listen, the guy was probably running around a lot, as was everyone in those early days of the case. I'm not trying to fault him specifically, but I think we can agree that that's a mistake, and it would have been good to record it even if you didn't know it was going to be important later. So again, hindsight is 20/20, but you can make a big deal about that. Certainly. And if you're the defense, you could say, hey, they didn't record this, so how do we know what he really said? Maybe it wasn't that bad, and like it shows how sloppy they are, and how are we supposed to take them seriously? They could do a lot with that. I think that would be a good move, and it could sway some jury members. But they lose that when they say, no, he's not sloppy. He's very meticulous, but it's a conspiracy. I mean, it's like you kind of actually lose the good point you have in that, because you're just trying to stretch everything to be this stupid Odinist theory. Like, I can't pretend to think that. I think this whole thing is just baffling that they've taken this approach to this extent. And this filing, in my opinion, is probably in some portions one of the better written ones we've seen recently. It's not like it has no merit. There are pieces of it that I think, hey, they're spot on here. Let's go. And it is just completely, any of that is drowned out by the through line that is this conspiracy with no evidence other than what we feel. And their feelings on the matter doesn't matter. I mean, like, that's irrelevant. What matters is, what do they have evidence for? But they don't seem to get that.
Are we done with that?
Yeah, let's move on.
So the next one is a memorandum of law in support of defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. The problem with this memorandum is they haven't proven what they're arguing for. I think it's a pretty well-written memorandum. And just to do a very quick, basic summary, they cite cases which says basically, well, if the prosecution does what we accuse them of, then the case probably should be thrown out. Mm-hmm. But the fact is they didn't offer any proof that the prosecution did what they said they did. Again, it's like with the Dan Doolin interview. If the recording existed and was intentionally destroyed or suppressed, then maybe that's something. And maybe other things are something. But they make these claims and they don't provide evidence for them.
And I guess I just wonder at this point, at this late time, this late stage of the game, is it a matter of they're just saying whatever to see what sticks? Is it a matter of they're like essentially okay with maybe outright lying in filings, or going up to that point, to the point where like you're definitely not telling the truth, or you're stretching things to the point where it's like the truth is not even in the room with us anymore? I mean, is it that? Is it incompetence? Is it rushing? I mean, I want to know what the heck is going on with this defense team, because, again, I've said this before, but if I were Richard Allen, or if I were Richard Allen's friends or family, you don't want to see this. You don't want to see this level of stretching. You want to see people who are making on-point filings that are resonant with the case law. I mean, they criticized Nick McClellan for not citing case law in a past filing, and I think that was an appropriate criticism. But in this, the case law doesn't match what they're saying at all. You know, it's like, wow, in a dream world, if what you were saying were true, this would be completely perfect. But it's not, and this is not what you were able to claim because you don't have any evidence for it. And I would be concerned. I think conspiracy theorizing is the last resort. That is the last stop on the road to defeat. I think that's a desperate move. And I think it concerns me that they seem to be going further down that road, because I don't think that's a place of strength. I think that's a place of, that's a retreat.
And again, I think we've talked about this before. The fact that Richard Allen has repeatedly made incriminating statements and or confessions seemingly to anyone that would listen makes me wonder if he is even interested in a trial, or if he wants to plead out. And given some things we've seen in this case, I would have concerns about his level of understanding of what's going on, and whether or not his wishes are being respected and followed by his attorneys.
At the risk of sounding something like Cato the Elder, I will just say that I feel that independent counsel needs to be brought in to assess Richard Allen's wishes and confirm that he's happy and content with what his defense team is doing, and that he, in fact, wishes to go to trial. It's okay if he changed his mind. It's okay if he confessed a bunch of times and said, oops, well, never mind. And then he wants to go forward with this. That's fine. But I don't necessarily know that that's the case, and it makes me really uncomfortable. And if this whole thing is being dragged out so that people can LARP as Clarence Darrow, or because other people do not want Allen to confess or to plead guilty, then that's a violation of his rights just as much as anything else. You know, you can't force people to go to trial for stupid reasons like that. It's got to be the person's choice. And so I think the only way you really get to the bottom of that is by having independent counsel who can verify that and just check with him, because it would be nice if this whole thing was not a tragic, ridiculous farce. In addition to that, we should talk a little bit about some things we've seen online recently.
Yes.
So I would say I'm just always curious about what the court of public opinion is doing. Not because it's necessarily important to the case. Ultimately, the most important thing is how the jury finds everything. But mostly because this defense team has made it so clear that the court of public opinion is very important to them personally. And I would say that I tend to kind of categorize people into different groups about the case. And there are almost two axes. I think it's guilt or innocence of Richard Allen himself and views on the attorneys. So on the guilt or innocence side, you see people who are convinced Allen is guilty and that it's a slam dunk case. And then there's people who feel Allen is guilty, but they don't think it's a slam dunk case. People who are currently unsure if Allen is guilty or innocent. People who are deliberately waiting until the trial and we get more facts to decide. People who feel Allen may be innocent, but there's a good case against him. People convinced Allen is innocent. People convinced Allen is innocent and is actively being railroaded by a conspiracy. So those are the different groups. And then Venn diagram with some of these opinions, but people convinced the defense team are willfully dishonest and not doing a good job. People convinced that the defense team is simply inept. People convinced that the defense team is fine people convinced that the defense team are the second comings of Clarence Darrow. Those are the various groups. Some people are in a couple of those groups. You yourself may kind of align with some of them. There's Venn diagrams that overlap, but I would say that's what I've seen. Since the contempt hearing, I think we've seen a pretty significant, online at least, boost in skepticism towards the defense team and their performance. And I would say that in addition to that, more recently, more coinciding with the talk about confessions and incriminating statements, we've seen more skepticism about loud claims that Allen must be factually innocent. Not necessarily people assuming he must be guilty, but certainly like skepticism towards some of the more egregious statements about how he must be being railroaded. So one thing that's interesting about that is, as we've seen that happen, and again, this isn't like, we're not statisticians. This is not statistical analysis. We're just talking anecdotally. We've seen a rise in public and behind the scene attacks on the victims' families. And I'm speaking particularly about Libby German's family. And I think one of the ugliest aspects of this case is some of the abuse online that they've experienced, and some of the rumors, the harassment, the creepiness. I mean, it's gotten bad at points, and I see it creeping back in that direction. And I think that will continue, because you do have people who I would say are kind of beyond the pale of reason and are more, I would characterize as maybe pro-defense conspiracy theorists. This does not incorporate everyone who thinks Allen's innocent. Plenty of people like that are just, rational, and that's their opinion, and that's great. I mean, like, that's not an issue. This is a small subset where I would think they kind of take it to an extreme, and it becomes more of a conspiracy theory thing. And I'm just concerned, because I think we're going to see a new effort to smear others as these more virulent pro-defense people feel that their base is shrinking. And I think we should be aware of that. And I think it's a situation of victim blaming, where they cannot blame the actual victims of this crime, Abby and Libby, because that would be too heinous and that would be extremely unpopular. But they basically take it out then on the victims' families, because they can be a target. And I just hope that doesn't continue to happen. But I feel like we should at least speak out on it to note that. Yeah,
I think it's outrageous. The reason we care about this case is because we care about Abby and Libby. No one in this world loves and cares about those girls more than their families. And they're the ones that have to deal with this loss, and will continue to deal with it for the rest of their lives, even after the attention of the world has moved on. And I think it is absolutely outrageous to be criticizing them.
And and it's not just criticizing. I mean, it's like outright smearing. It's outright attacks, accusations that they're part of the Odinist cover-up. I mean, it's ridiculous. I mean, it's not just like, oh, I don't like what they said. It's like, it gets very dark and nasty very fast. And I'm just going to say, like, I feel like for most people who follow this case, that it's people want to know, people want to be informed. It's a good impulse to want to know and be informed. It's a good impulse to care. It's a good impulse. And so when I say this, I think maybe like 95% of people are absolutely fine who are interested in this case. But I think there's like that 5% where it's just kind of twisted itself into this hobby, where it's about like, ooh, how clever can I be on the internet? And I can piece together the clues. I'm Sherlock Holmes. And I feel like in those people's minds, the girls, their families, and any actual sincere care about Richard Allen's right to a competent defense, those are just long forgotten afterthoughts. And that concerns me, because I think, unfortunately, while they're very much the minority, they're very loud. They're very, very loud. And they have the power to harass people. They've certainly harassed people in the past. And I just do not want to see that being directed at this family again, because I feel like they've been through enough. And if this case continues to drag on, we're all in for a long haul. And I'm just concerned it's going to get darker and nastier as we go along.
Yes. And if you're attacking the family, you've lost the plot.
Agreed. Anyways, is that all we wanted to talk about?
Yeah, I was trying to think of a good Cato Kalin quote, but
I mean, what?
well, I mean, usually on a true crime podcast, when you talk about Cato Kalin, you're talking about another Cato. I'm just all confused. But I'll spend some time trying to piece all that together.
Can I ask who is Cato Kalin?
So what you've done just now on a true crime podcast is you've humiliated and shamed yourself. So don't say who Cato Kalin is. Don't say who Cato Kalin is. I will have a long, long conversation with Anya about this after the show. So thank you so much for listening. Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.